Hello everyone, hope everyone is doing great. My name is Teja, the voice behind UPSC Tribe. In today's class, let's discuss about the High Court. In the Constitution of India, Part 6, Article 214 to 231 of the Indian Constitution deals with the High Court. High Court is the top court in the state. The Supreme Court of India stands above the High Court. Below the High Courts, the district courts and subordinate courts exist. When we look at the hierarchy and structure of Indian judiciary, we will see that the subordinate courts are responsible to the district courts and district courts are in turn responsible to the High Court. The High Court of any state in India is responsible to the Supreme Court. In 1862, at Kolkata, the first High Court was formed. Please note, Kolkata High Court is the oldest High Courts among all the High Courts present today. In 1862, in Kolkata, Bombay, Madras and High Courts were formed. In 1866, Allahabad High Court was formed. The 7th Amendment Act of 1956 has decided there can be a common High Court for 2 or more states or 2 states or union territory. At present, there are 25 High Courts. Out of them, 6 High Courts are dealing with more than 1 state or union territory. For your reference, Delhi has its own High Court and the union territories of Jammu and Kashmir and Ladakh has a High Court in common. By an act of Parliament, Parliament can extend the jurisdiction to UT or exclude the jurisdiction of High Court. It is in the hands of the Parliament. Now, let us see the composition of the High Court. High Court consists of a Chief Justice plus other judges. The strength is determined by the President from time to time. The appointment of the Chief Justice and other judges of the High Court is made by the President of India in accordance with Article 217 of the Indian Constitution. It is in consultation with the Chief Justice of India plus Governor of the concerned state. Let us look at the appointment of the Chief Justice of the High Court. Here I have mentioned a pipeline where describing how the appointment of the Chief Justice take place. Let's look into this. At first, the Supreme Court Collegium, whenever there is a vacancy that appears in any High Court, the Collegium of the Supreme Court, that is, the Chief Justice of India plus 2 senior most judges of the Supreme Court, will send a recommendation to the Ministry of Law and Justice. The Ministry of Law and Justice, after taking the views of the Chief Minister and Governor of the concerned state, sends it to the Prime Minister. The Prime Minister places the recommendation report before the Cabinet and Cabinet sends, that means the Prime Minister sends it to the President of India for approval. When the President of India approves the appointment of the Chief Justice of High Court, it is notified by the Department of Justice. Let us now see how the other judges of the High Court is appointed. The same Supreme Court Collegium which consists of CJI plus 2 senior judges plus CJ of the current High Court where there is a vacancy plus Governor of the concerned state will look into these matters. If the High Court the jurisdiction of the High Court is concerning to 2 or different states, the views of the governors of the two states is taken into consideration. Now, you may think, what does a collegium mean? Now let us look into this. A collegium, let's say it's a body of judges who appoints the judges for various High Courts and Chief Justices of various High Courts. Let us see it in literal sense. It is a forum which decides appointments and transfers of judges. The collegium not only deals with the appointment of judges, but it also deals with the transfer of the judges. Now let us look into the evolution of the collegium system. There are 4 judges cases that are relating to the collegium system. Now first look at the first judges case of 1981. This is also called as SP Gupta case. In the Constitution of India, in Article 124, there is a mentioning of the word consultation. In 1981 case, in the first judge's case, the Supreme Court opined that the executive consultation to the Chief Justice doesn't mean concurrence to his opinion. In this case, the primacy is given to the executive. That means even if the CJI says no to such appointments, it is not mandatory to the executive to stick to the word of the CJI. Once again in brief, the first judge's case of 1981 opined that the consultation doesn't mean concurrence, that the executive primacy is mandated in this case. Let's look into the second judge's case of 1993. It is also called as the Supreme Court's Advocates on Record Association versus the Union of India. In this case, Honorable Supreme Court ruled that consultation means concurrence. That means when you consult the CJI for his opinion, that opinion must be respected and the decision must be concurrent in regards to that decision of the Honorable Supreme Court. The collegium system was introduced in the second judge's case, wherein 1 plus 2, the Chief Justice plus 2 other senior most judges of the court must be consulted before appointments and transfers. In this case, CJI is given more primacy than to the executive. The second judge's case of 1993 ruled out the first judge's case. Let us now look into the third judge's case of 1998. This case expanded the collegium. Honorable Supreme Court of India opined that there need to be larger negotiations for the appointment of judges of the High Court and Supreme Court, so that the Supreme Court expanded the collegium from CJI plus 2 members to CJI plus 4 senior judges of the High Court. Now the collegium is CJI, Chief Justice of India, plus 4 other senior most judges of the Supreme Court. In 2015, in the 4 judges case, the same Supreme Court Advocates on Record Association versus Union of India, this Honorable Supreme Court struck down the 99th Constitutional Amendment Act of 2014. The 99th Constitutional Amendment Act of 2014 talks about the National Judiciary Appointments Commission, a commission formed by the Union of India to appoint the judges of High Courts and Supreme Court. Stating the independence of the judiciary as a reason, Honorable Supreme Court of India struck down the 99th Constitutional Amendment Act of 2014, opining that this Amendment Act is ultra-vires to the Constitution. The Honorable Supreme Court declared it as unconstitutional and void. Now let us look into the qualifications of judges of the High Court. One, to become the judge of a High Court, one must be a citizen of India primarily. He should hold a judicial office for 10 years, or he should be advocate practicing in an High Court for 10 years. Please note, there is no mention of minimum age for the appointment of the judge of a High Court. Unlike the Supreme Court, there is also no mention of the word jurist in the High Court. That means no jurist is eligible to become the judge of the High Court. The judges of the High Court take oath or affirmation. The oath or affirmation of the judge of High Court is made before the governor. The judge of High Court takes oath to bear true faith and allegiance to the Constitution of India, to uphold the sovereignty and integrity of India, to duly and faithfully, to the best of his ability, knowledge, and judgment, perform the duties of his office without fear, favor, or ill affection or ill will. Also, the judge of the High Court swears that to uphold the constitution and the laws of the land. Now let us look into the salary and allowances of the High Court judge. The salaries and allowances of the judge of the High Court are determined by Parliament from time to time. Please note, the salaries of the judges of the High Court is paid out of the consolidated fund of the state. It is paid out of the consolidated fund of the state, not out of the consolidated fund of India. The consolidated fund of the state is discussed in the state legislature but is not put to vote. Whereas the pension is paid out of the consolidated fund of India. To be brief, whereas the salary is paid out of the consolidated fund of the state, but the pension is paid out of the consolidated fund of India. The salary and allowances of the High Court judge cannot be varied to his disadvantage. He is also eligible for the sumptuary allowance, for medical expenses, free residence, and other amenities provided by the Parliament from time to time. Now let us look into the tenure of the judges. The Constitution does not mention the fixed tenure of the judges, whereas the 62 years of age is mentioned in the Constitution. That means until 62 years of age, a judge can be uphold his position. If one crosses 62 years of age, is not eligible to become the judge of a High Court. In the disputes regarding the age of the judge of the High Court, the decision of the President is final. The questions regarding the dispute is dealt by the President of India. The judge of a High Court can resign by writing to the President of India. When a judge of a High Court is appointed as a Supreme Court judge or transferred to other High Courts in the public interest, the vacancy in the office of the judge occurs. Now, very important point, let us look into the removal of the judges of the High Court. I guess this is an important thing, seeing the present circumstances that were going on in the democratic system of India. Now let us quickly and in detail look into the removal of the judge of the High Court. The judge of a High Court is removed by the President on recommendation of the Parliament. Although appointed by the President, he is removed by the President on recommendation of the Parliament. The grounds that were mentioned in the Constitution for the removal of judges is proved misbehavior or incapacity of a judge. If a judge is proven guilty for his misbehavior or he is incapacitated, that he is unable to hold his office, such judge can be impeached by the procedure duly mentioned in the Judges Inquiry Act 1968. The procedure of removal of judges was regulated by the Judges Inquiry Act of 1968. In the first stage, a removal motion signed by 100 members in the Lok Sabha or 50 members in the Rajya Sabha is submitted to the presiding officer. That means, in case of Lok Sabha, 100 members must sign the motion and submit it to the Speaker of the Lok Sabha. In case of Rajya Sabha, 50 members of the House must sign the removal motion and submit it to the Chairman of the Rajya Sabha. It is upon the presiding officer to admit or refuse to admit the same motion. If a motion is admitted Then presiding officer constitutes a 3-member committee. The 3-member committee consists of Chief Justice of India or a judge of a Supreme Court. The second person is CJ of the High Court, Chief Justice of the High Court, and a distinguished jurist. Please keep in mind, the presiding officer, once the motion is admitted, he appoints a 3-member committee. The 3-member committee consists of CJI, Chief Justice, or any other judge of the Supreme Court, the Chief Justice of a High Court, and also a distinguished jurist. If the 3-member committee founds that the judge is guilty, the House takes up the motion. When the House takes up the motion, it needs a special majority to get the motion passed. A special majority means 2/3 of the members of the House present and voting, and the majority of the members present and voting that day. It means special majority. When the motion is passed at Lok Sabha and Rajya Sabha, when the motion is passed both at the Lok Sabha and Rajya Sabha, it is sent to the President of India. Honorable President of India releases an order impeaching the judge who is found guilty. This is the procedure for the removal of the judge of a High Court. It involves 7 steps. Please keep in mind all these 7 steps. The numbers like 100 members signing the motion in Lok Sabha and 50 members in Rajya Sabha, and also the special majority. Now let us look into the transfer of judges. The third judge's case of 1998 has widely said that there is a need to consult for extensive consultation. That means the Honorable Chief Justice of India should consult the 4 other senior most judges of the Supreme Court for the transfer of the judges. And also the CJs of the 2 High Courts must be consulted. Here the CJs of the 2 High Courts means the High Court from where the CJI is moving out and the receiving High Court. For the transfer of judges, the Supreme Court Collegium, that is CJI plus 4 senior most judges of the Supreme Court, including the CJs of the 2 High Courts, recommends the transfer. The President of India, after consulting with the Supreme Court Collegium, transfers the judges. The transfer of judges is not a general rule, but it is an exceptional measure. It is not made as punishment to the transferred judge, but it is made keeping in view of the larger public interest. For the good of the state, a judge is transferred from one state to the other. The transfer of judge, the matter concerned regarding this is also subject to the judicial review. But the only transferred judge can only challenge it in the Supreme Court. When a judge of a High Court is transferred from one court to the another, he is eligible to receive the compensatory allowance. The Constitution also provides for the acting Chief Justice or acting judge. The acting Chief Justice or acting judge of a High Court is appointed by the President. When office of the Chief Justice of a High Court is vacant, if the Chief Justice is temporarily absent or is incapacitated or in a position unable to perform his duties, an acting Chief Justice can be appointed by the President of India. Also, the Constitution specifies regarding the additional judges. The President appoints the additional judges for a temporary period. It is generally not exceeding a period of 2 years. Due to the increased business of work or the pendency of the cases in the court, the President of India will appoint the additional judges. The 62-year age limit, as we discussed, is eligible to the additional judge also. If the President of India desires, upon the request of the Chief Justice of the High Court, a retired judge can be appointed for the temporary period. A retired judge is reappointed because keeping in view of the pendency of the case, the workload and the burden on the judiciary. This is a temporary relief, not a permanent thing. Now let us discuss about the jurisdiction and powers of the High Court. This is an important aspect that need to be discussed. The Constitution of India, like the Supreme Court, vests the High Court with extensive judicial powers. As the High Court is the highest court of appeal in the state, it is also the protector of the fundamental rights of the citizens of the country. The High Court is also vested with the powers to interpret the Constitution. Now let us look into the original jurisdiction of the High Court. The original jurisdiction means the jurisdictional power of the High Court to listen, to hear the matters, to hear the disputes at the first instance. Generally, the aggrieved parties approach the High Court in the state in way of appeal, but the High Court of the state has the original jurisdiction. It can be approached directly by the citizens in the first instance, but not by way of appeal. The High Court has a power to hear the cases in the first instance. It extends to the following situations or conditions, like the matter of admiralty. Admiralty means matters concerning to the deep waters or the vessels and the larger ships that take voyage in water, regarding that, and contempt of court and issues related to the contempt of the court. We'll discuss the contempt of court in the next section deeply and in detail. The High Court of the state can look into the election disputes of both the members of the parliament and also the state legislature. If a matter arises regarding the disqualification or the eligibility criteria of a parliament member or a member of the state legislature, one can approach the High Court directly. Also, the jurisdiction of the High Court, the original jurisdiction, is also related to the matters of the revenue collection. When the fundamental rights of an individual is infringed, the citizen can approach the Honorable High Court under Article 226 directly without visiting or without approaching the lower court. The constitutional guarantees is made under Article 226 of the Indian Constitution. The High Court, like the Supreme Court, interprets the Constitution. If a case in a subordinate court involves a constitutional interpretation, the High Court of that jurisdiction can transfer the case from the subordinate court to itself and interpret the Constitution or deal it fully. Or it can also, after interpreting the Constitution, can send back to the concerned subordinate court In the civil matters involving large amounts of money, the High Courts of Madras, Calcutta and Bombay and Delhi as the original jurisdiction in the matters pertaining in the civil matters of high value. Now, let us understand the important jurisdiction of the High Court, that is writ jurisdiction. I have just now mentioned when the fundamental rights of the citizen of this country is violated, he can approach the High Court directly under Article 226. The High Court of a state issues certain writs. About writs, we will discuss while discussing the fundamental rights. There are 5 writs that are mentioned in the Constitution. These writs are to protect the citizens of the country from the excessive power of the state. The writs like habeas corpus, mandamus, certiorari, prohibition, quo warranto, and also, unlike the Supreme Court, whenever there is an infringement of ordinary legal right, not only the fundamental right but also the infringement of the ordinary legal right, the aggrieved party can directly approach the High Court under the writ jurisdiction. The High Court has a power to take up the matters pertaining to the territorial jurisdiction of the state and also the outside territorial jurisdiction if the action takes place in outside the territorial jurisdiction of the case. That means the writ jurisdiction of the High Court extends. It operates within the state and also it extends outside the territorial jurisdiction of the concerned High Court. The writ jurisdiction of the High Court is not exclusive. Supreme Court also has the writ jurisdiction. Whenever the infringement of fundamental right happens, whenever someone's FRs are violated, they can approach the Honorable Supreme Court of India under Article 32 of the Indian Constitution. So, this says that the writ jurisdiction of the High Court is not exclusive to the High Court. It is also applicable to the Supreme Court of India. Whereas the Supreme Court's writ jurisdiction is slightly narrower when in comparison to the writ jurisdiction of the High Court. The writ jurisdiction of the High Court is wider because whereas the Supreme Court can only issue writs, 5 writs in the violation of the fundamental rights, but High Court of a state can issue writs even an ordinary legal right of a citizen is infringed or taken away by the state, so that the writ jurisdiction of the state High Court is wider. The writ jurisdiction is part of the basic structure of the Constitution. In Chandrakumar case of 1997, Honorable Supreme Court opined that in any manner, even by the Act of Parliament, the writ jurisdiction cannot be excluded, even by the way of amendment by the Parliament. Now, let us look into the appellate jurisdiction. There are matters concerned. There are both civil and criminal matters that the High Court deals with. At first, the in case of civil matters, always the subordinate courts are first approached by the aggrieved parties. If the justice is not done to the aggrieved party, then the aggrieved party can approach the High Court in appellate jurisdiction. In the first appeal, the question of law and the facts of the case are examined by the High Court while delivering the judgment. In case of the second appeal in civil matters, the only question of law is considered. The facts are not used at this stage. If the party is unhappy with the decision or the judgment of the single judge bench of the High Court, he can approach the division bench of the High Court. He can appeal to the division bench of High Court to review his case. The High Court acts as the court of first appeal for the matter pertaining to the decisions of the tribunals. I also earlier mentioned that in some states like Bombay, Calcutta, Delhi, if a case has a larger value, the citizen can approach the High Court directly. Now let us look into the criminal matters, how appellate jurisdiction works. If a case involves a punishment, if a criminal case that is the decision is made by the sessions court or the additional session courts in the subordinate level, which involves 7 years imprisonment, 7 or more years of imprisonment, such cases can be appealed at the High Court. The judgments of the session court can be appealed at the High Court. Even when a sessions judge or the judge of the additional sessions court pronounces a death sentence, that is usually the capital punishment, the Honorable High Court is approached for the confirmation. Now let us look into the supervisory jurisdiction of the High Court. The High Court not only has the appellate jurisdiction and writ jurisdiction, it also has a superior supervisory jurisdiction. As the High Court stands after the Supreme Court of India, below the High Court there are the other subordinate courts below the High Court. In the state, the High Court is at the top, and the next level, other subordinate courts. The supervisory jurisdiction of the High Court is applicable to all the subordinate courts in the state, except there is an exception for the tribunals and the military courts. The High Court can make and issue rules for the functioning of the lower courts or the subordinate courts. It also prescribes forms for regulating practice and proceedings in the lower courts. It also settles the fees payable to the officers of the court and also the other legal practitioners that were practicing in the lower courts. The High Court enjoys the administrative and judicial superintendence over all the other subordinate courts in the state. There is an interesting thing. Not only the supervisory jurisdiction, the High Court also enjoys the revisional jurisdiction. Revisional jurisdiction means a decision or a judgment that happens in the lower court, when there is some misinterpretation in the lower court judgment, the High Court can directly transfer such case to the High Court and revise the judgment. This is the revisional jurisdiction. It is sparingly used or utilized by the High Courts in the state. The High Court has the power to take the suo motu cognizance of the case to revise the judgment of the lower courts. Let's now look at how the High Court control the subordinate courts below it. In the judicial appointments of the judges of the lower judiciary, the governor of the state consults the High Court for their appointments. The High Court directly deals with the matters of transfer or the posting or grant of leave to the judicial officers in the lower courts, and also other judges in the lower courts. The matters regarding discipline in the lower courts and also officers of the court is concerned and directly supervised by the High Court in the subordinate courts. If there is a case that requires the interpretation of the Constitution, for example, a case is going on the subordinate court and it requires the interpretation of the Constitution, then Honorable High Court on its own can withdraw that case, take suo motu cognizance of that case, transfers that case to itself, and interprets the Constitution in that case. It can also deliver the final verdict, or it can send it to the subordinate court after the interpretation for the final verdict. The decision of the High Court, or the rules set by the High Court, or the framework of the High Court that is made for functioning of the lower courts is binding on all the subordinate courts that is functioning in its territorial jurisdiction of the High Court. The High Court is the court of record, like the Supreme Court. Both the High Court and Supreme Court are the courts of record. By the court of record, we mean the judgments and the proceedings that are delivered by the High Court from time to time, or the Supreme Court from time to time, are recorded for the perpetual memory. After recording, these cases can be used as judicial references in the future course. These judgments, which are recorded for the perpetual memory, becomes references in the future judgments or in solving the future cases. They act as the legal precedents. The High Court has the power to review its own judgment and to correct its own judgment. The Supreme Court also has the same power. Supreme Court also has the power to revise the judgments of the High Court, whereas the High Court has the power to revise the judgment of the subordinate courts. It is an hierarchy. When you understand the structure, these things become so easy. Contempt of court. This is the important thing, as we said. Regarding the contempt of court, there is no mention, there is no definition regarding the contempt of court in the Constitution of India. I think there is a mention, but it is not defined. The contempt of court is defined in the Contempt of Courts Act 1971. The contempt of courts is regulated by the Contempt of Courts Act 1971. There is civil contempt and criminal contempt. Let's understand the difference. Civil contempt means when a person or a government agency or some organization, some authority in power willfully disobeys the order of the Honorable High Court, it attracts the contempt of court. That means willfully disobeying the judgments of the High Court amounts to contempt of the court. High Court can punish by way of fining them or jailing them. In the criminal contempt, if someone tries to scandalize the authority of the court, or they make some willfully wrong comments on the judges of the High Court, or for this matter also the Supreme Court, it attracts the criminal contempt of the court according to the 1971 Contempt of Court Act. The High Court holds the power of judicial review. In 42nd Amendment Act of 1977, the power of judicial review of the High Court to review the matters the Parliament Acts was taken away, but it was restored by the 43rd Constitutional Amendment Act of 1977. This Constitutional Amendment Act thus becomes important to us. by the High Court has the power to review both the executive orders and legislative enactments. That means orders of the officials in the government and also the laws that were passed by the legislative organs like Lok Sabha, Rajya Sabha, like Parliament and state legislatures. The power of judicial review of the High Court is applicable to both the center and state laws. Please keep this point in mind. It is not only applicable to the state laws that were made or the executive orders of the state, but it is also applicable to the executive orders of the center and also legislative enactments of the center and state. Exclusively or explicitly, there is no mention of judicial review in the Constitution, but Article 226 itself is self-explanatory regarding the matter of judicial review in the High Court. To protect the independence of the High Court, the Constitution of India has guaranteed few things to the judges of the High Court. It is guaranteed to them to deliver justice without fear or favor to anyone. Let us look into the independence of the High Court, how it is independent. It is independent from both the pressure of the executive, from the legislatures and other counterparts. High Court takes decision on its own will. No interferences from the other organs happens in it, like the organs of the legislature, maybe the organs of the executive. The mode of appointment. We know the judges of the High Court are appointed under the seal and warrant of the President of India. There is also fair procedure. The collegium appoints the judges to protect the independence of the judiciary. The system of collegium is established by the third judge's case. The security of tenure. The security of tenure of the High Court judge is guaranteed by the Constitution. A judge of a High Court cannot be removed to a disadvantage, or his compensation cannot be, the allowances, salary cannot be decreased to his disadvantage. There are the fixed service conditions are pertaining to the salary allowances of the High Court. They cannot be decreased to his disadvantage. There is a security of tenure guaranteed to the judge of the High Court. He is only transferred keeping in view of the public interest, not as a punishment. Now let us look into the fourth point. The salary, as we have discussed, the salary and other allowances paid to the Honorable Judge of the High Court is paid out of the consolidated fund of the state, because the consolidated fund of the state is not put to vote but discussed in the state legislature. It gives paramount independence to the judge because he cannot be influenced financially even by the legislature, so it increases the independence of the High Court. Also, in the fifth point, the conduct of the judges cannot be discussed in the state legislature or the parliament. The Constitution explicitly states the acts of judges or the proceedings of the court cannot be discussed in the legislative wings like state legislature or the parliament, unless if it is a matter regarding the removal or the impeachment of the judge. Thus, it can only be discussed then, not at other times. There is a ban on practice after retirement. Once a judge retires, he cannot practice at the subordinate courts or other bodies. But there is an exemption to this. The judge can practice before the High Court and before the Supreme Court only. If someone disobeys its orders willfully, the High Court is guaranteed with power to punish for its contempt. The High Court enjoys the freedom to appoint the staff in its lower courts. Thus, the independence of the High Court increases because there is no interference of the executive in the appointments of the judicial appointments. It can, on its own will, can appoint whoever seems fit for the disposal of judiciary duties. The jurisdiction of the High Court cannot be curtailed by the law of the Parliament. This increases the independence of the High Court. The Constitution of India, in Article 50 of the Directive Principles of the State Policy, asks the state to take measures to see to it that there are separation of powers from executive. So there is a constitutional guarantee which increases the independence of the High Court. The 10th point is discussed, that is separation of powers from executive. Now let us look into the previously asked questions. There are some questions that were asked in 2017 prelims. So now let us look into that. As usual, let us first read the question and let's solve it later after reading that question. In India, first question, in India, judicial review implies. We have discussed what does judicial review means in the above section. So this question is asked in the 2017 prelims. Option A, the power of judiciary to pronounce upon the constitutionality of law and executive orders. Option B, the power of the judiciary to question the wisdom of the laws enacted by the legislatures. The powers of the judiciary to review all the legislative enactments before they are assented by the president. No. The power of the judiciary to review its own judgments given earlier in similar or different cases. As we have discussed earlier, judicial review means reviewing both the legislative enactments and the executive orders. The option A stands as best fit for us. The power of judiciary to pronounce upon the constitutionality of laws and executive orders. This is the best fit. So option A is the correct answer for this. Second question. With reference to the Constitution of India, consider the following statements. This question is asked in UPSC CSE 2019 prelims. First statement. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. An amendment of the Constitution of India cannot be called into question by the Supreme Court of India. Which of the following statements are correct? There are two statements given here. They are asking which of the statements are correct. No High Court shall have the jurisdiction to declare any law to be constitutionally invalid. I have earlier said the High Court has the jurisdiction to declare both the state and central laws invalid if they are against the will of the Constitution. So, this first point is wrong. It is incorrect. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. Oh man, the Supreme Court of India enjoys the power to review the constitutional amendments even. So both the statements are wrong. Which of the following statements is correct? Neither one nor two. Let's look into the third question. With reference to the Indian judiciary, consider the following statements. This question was asked in the UPSC CSE 2021 prelims. First statement, any retired judge of the Supreme Court of India can be called back to sit and act as Supreme Court judge by Chief Justice of India with prior permission of the President of India. Yes, this is applicable in case of the Supreme Court also. As earlier we have discussed that any retired judge of a High Court can be called back by the President with the prior permission. Can be called back by the Chief Justice with the prior permission of the President. And he can be asked to discharge duties if there is a burden of or pendency of the cases. So, first statement is right. A High Court in India has the power to review its own judgment as the Supreme Court does? Yes, the High Court can review its own judgments. So both 1 and 2, both statements are correct. Fourth question, consider the following statements. Pursuant to the report of the H.N. Sanyal Committee, the Contempt of Court Act 1971 passed. Yes, this is true. After the constitution of H.N. Sanyal Committee, the Contempt of Court Act 1971 was passed. The Constitution of India empowers the Supreme Court and High Courts to punish for contempt of themselves. Yes, both the Supreme Court and High Court can punish for both the criminal and civil contempts. The Constitution of India defines civil contempt and criminal contempt. No, the Constitution of India doesn't define. There is only mention of the contempt of court in the Constitution, but it is exclusively mentioned in the Contempt of Courts Act 1971. So the third statement is wrong. It is incorrect. Fourth statement. In India, the Parliament is vested with the powers to make laws on contempt of court. Yes. Actually, in 1971, the Contempt of Court Act was made in the Parliament. The fourth statement is self-explanatory. So the statements 1, 2 and 4 are correct. Yeah, option B. Option B is correct here. So now I have some value addition material for you guys. This is important table. Please read it well by heart, because in few examinations, in some questions were asked regarding the jurisdiction of the Union territories, which High Court they belong to, the jurisdiction of those UTs belong to. So please keep this in mind. Keep this Kerala High Court, Lakshadweep, K. Kerala High Court, L. Lakshadweep, KL Rahul. For your remembrance, for your memory, I'm just telling that. I hope you have enjoyed this class. Please write in the comments below have you enjoyed this class, and let's meet in the next class. Thanks for watching so patiently. Signing off. Jai Hind.